Today's hearing, I call this hearing to order. Before we get started, please join me for a short moment of silence. Thank you very much. Moving to the roll call for the commissioners. District 1.
Present.
District 2.
This is Commissioner Belser. I'm present in the hearing room.
District 3.
Commissioner Randall, I'm present from my office here at the commission.
District 4.
Commissioner Irvin, I'm joining you virtually due to the COVID-19 virus.
District 5.
Whitfield present in District 5 virtually.
District 7.
Hamilton present virtually.
And District 6 is here present in the hearing room. Thank you, commissioners, for joining us for today's hearing. Attorney Jerisha Dukes, please read the docket.
Thank you, Mr. Chairman, and good morning. This proceeding is before the Public Service Commission of South Carolina in docket number 2019-387-A for the purpose of promulgating a regulation to help prevent the potential for misleading advertisements by prohibiting the sale of customer data by regulated utilities absent a customer's direct consent. In the filing of the proposed regulation with the General Assembly, members of the public were given an opportunity to submit written comments and to also participate in today's virtual public hearing. Mr. Chairman and other members of the Commission, the docket is in order.
Thank you very much, Attorney Dukes. Before I call on Public Service Commission Counsel, Attorney Jocelyn Boyd, who's the Executive Director and Chief Clerk of the South Carolina Public Service Commission, I want to make sure the parties are present and make themselves known. Who's representing Dominion Energy?
Good morning, Mr. Chairman. My name is Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina, and with me today, albeit virtually, is Belton Ziegler, who is the company's outside counsel from the law firm of Womble Bond Dickinson.
Thank you, Attorney Burgess and Attorney Ziegler. Who's representing the Duke companies?
Good morning, Mr. Chairman, members of the Commission. I'm Katie Brown, in-house counsel for Duke Energy Carolinas and Duke Energy Progress. Here with me today virtually is Sam Wilborn. He's outside counsel for the companies with the law firm of Robinson Gray.
Thank you, Attorney Brown and Attorney Wilborn. Piedmont Natural Gas.
Good morning, Commissioner. My apologies. I cannot seem to get my video to work. My name is Mindy McGrath. I am outside counsel for Piedmont Natural Gas. I'm at the law firm of McGuire. Piedmont did not file comments in this docket and has not taken an active role, so my participation today is primarily for the purposes of monitoring today's proceeding. Thank you.
Thank you, Attorney McGrath, and we appreciate you joining us today. The South Carolina Department of Consumer Affairs.
Good morning. I'm Kelly Ransford. I am the Deputy Administrator and General Counsel for the South Carolina Department of Consumer Affairs. And with me virtually is Carrie Gruby-Leibarker, who is the Administrator and Consumer Advocate for the Department.
Thank you, Attorney Ransford and Attorney Leibarker. Town of Irmo.
Hello, Mr. Chairman, and welcome home. This is Jake Moore.
Good morning, Attorney Moore. Good to see you. Happy to be home. Thank you for the welcome. I have to get by there and see you all in the firm at some point before the end of the year. Thank you.
Like that.
Yes, sir.
Mr.
Thank
Chairman,
you.
My comments will be incredibly brief this morning.
Okay. Okay, we'll take that in consideration, Attorney Moore. Thank you very much. Office of Regulatory Staff.
Good morning, Mr. Chairman. This is Chris Huber here for the Office of Regulatory Staff.
Is it just you?
Yes, Mr.
Okay.
Chairman.
All right, thank you. Blue Granite Water Company?
Mr. Chairman, this was late filed, but Blue Granite will not be participating this morning. Thank you.
Thank you, Attorney Welborn. Consumer Data Industry Organization? Okay, I guess they're not here with us. That is the role of the parties here joining us for today's hearing. Ms. Boyd, could you please present the proposed regulation?
Yes. Good morning, Mr. Chairman. Thank you for allowing me the opportunity to present a summary of the regulation that's before the commission today. And prior to me presenting a slide deck regarding the proposed regulation that's before you, I'd like to ask that certain documents be made a part of the record this morning.
Yes, ma'am, please proceed.
Mr. Chairman, I'm making this request pursuant to South Carolina Code annotated Section 1-23-111 regarding jurisdictional documents in the docket. So I would ask that the proposed regulation, the notice of drafting that was published in the State Register, the proposed regulation that was published in the State Register, verification of the proposed regulation, in addition to other documents that are in the docket, including the Office of Regulatory Staff's proposed regulation dated December 20th, comments that were filed after the notice of drafting from Dominion Energy South Carolina, Duke Energy Carolinas, and Duke Energy Progress. I apologize. I don't want to state their abbreviated name. I'll get back to them in just a second. Attorney Jake Moore on behalf of the town of Irmo. Consumer Data Industry Organization's comments that were filed with the commission after the notice of drafting was published. Also, the Public Service Commission staff compiled the comments and served the stakeholders who had previously provided comments in the docket on April 2nd. So I'm asking that those become a part of the record. After the commission published the proposed regulation, we received comments from Dominion Energy South Carolina, the South Carolina Department of Consumer Affairs, Duke Energy Carolinas and Duke Energy Progress, Duke Energy Carolinas LLC and Duke Energy Progress LLC, and finally, staff posted some comments yesterday on DMS and served the stakeholders regarding the August 3rd comments that were filed with the commission. So those are all the documents, Mr. Chairman, I ask be made part of the record.
Thank you, Ms. Boyd. All the documents you identified will be marked as a composite exhibit, and entered into the record as hearing exhibit 1.
Okay. Mr. Chairman, what I need to do next is I have a PowerPoint slide where I would like to go over some highlights for today's regulation.
Please proceed.
All right. All right, I'm gonna have to use the enter button. So, real briefly, some history, Mr. Chairman. On November 25th, during the commission's regularly scheduled commission business meeting, Commissioner Irvin moved for the commission to open a new docket and for the Office of Regulatory Staff to investigate a utility's alleged sale of customers' personal information to a third party. Commissioner Irvin's motion also requested that the Office of Regulatory Staff report its findings or recommendations to the commission as soon as practicable. Commissioner Irvin's motion, of course, passed, and the commission issued order number 2019-812. Thereafter, on November 27th, 2019, the Office of Regulatory Staff filed a petition for rulemaking related to the sale of customer data. On December 18th, 2019, once again during the commission's regularly scheduled commission business meeting, the commission approved the Office of Regulatory Staff's request to initiate a rulemaking, and the commission ordered a docket to be open for the rulemaking. On December 20th, shortly thereafter, the Office of Regulatory Staff filed with the commission the ORS's proposed regulation to protect customer data. Activity began in January with the commission staff filing by the second Friday in January a notice of drafting with the South Carolina Legislative Council. That notice of drafting was published in the State Register on January 24th, 2020. And then, as I just asked, certain comments were filed by interested stakeholders. Mr. Chairman, after the notice of drafting was published, the commission staff then compiled those comments. That's that April 2nd date that you see, and just the top portion of that document that is posted on DMS that lists some of the stakeholders who filed comments, and as best we could, included those comments in a color-coded format on the proposed regulation. After April 2nd, 2020, the commission staff filed with the Legislative Council proposed regulation by the second Friday in June, and the proposed regulation was published the last Friday, of course, in June, or the fourth Friday, I should say, not the last. It's always the fourth Friday in June, on June 26, 2020. Okay, so the purpose, as you already know, for the regulation before you today is to provide a regulation guidance to utilities as to how customer data, which customer data, what needs to be protected as it relates to customer data. What's very important, of course, is what is customer data? And Mr. Chairman, the customer data is defined under Section A3 of the regulation, and it includes usage, information, or data regarding the customer's usage for the services it receives from electric, natural gas, water, or wastewater utilities. It also includes data related to other issues such as advanced metering infrastructure, personal identifying information, for example, the customer's account number, name, billing history, and all of that. Of course, there is an additional definition of customer data. I'm not going to read it all, but it's basically sensitive. I guess the way I would categorize it is sensitive information that it pertains to individual customers about their utility service. All right, the next definition I thought important because it was one of the reasons Commissioner Irvin's motion was made, I believe, is the definition of third party. What happens when that data leaves the utilities control? All right, so third party is defined under A7. Third party is defined as a person who is not the customer nor any of the following: an agent of the customer, designated by the customer, a regulated public utility serving the customer, or a contracted agent of the public utility. The definition also states that third party includes any non-public utility operations or affiliate of the public utility. Aggregated data is also defined, and unique identifier is also defined. So after looking at the issues of what's customer data, if the data leaves the utilities control, that's the phrase I'm using, and it enters into the third party's hands, what needs to happen before that based on the wording of this regulation? And the phrase customer consent is extremely important. It's under Section C, and basically Section C basically states that unless there is an exception that is articulated in Section F of the regulation, a customer's consent must be obtained prior to the release of the customer data by the utility. Section C basically states a public utility shall not share, disclose, otherwise make accessible, or sell customer data, basically without the consent of the customer. Section C4 mentions full disclosure. Should the utility relinquish this data to a third party? Before requesting a customer's consent for disclosure of customer data, a public utility shall be required to make a full disclosure. And then Section 4 also indicates what full disclosure includes. Some other highlights I thought worth mentioning: Section D of the regulation pertains to secondary commercial primary commercial purpose is defined in the regulation basically as utilities providing or maintaining data related to its provisioning of utility services to the customer. If it's not related, if the purpose is not related to the primary purpose, then the definition states everything else is a secondary commercial purpose. Section D basically states that a public utility might end up contracting with a third party, and that third party is providing a service where the customer can monitor his or her usage, utility usage. If the third party that's providing that service so that the customer can monitor the customer's usage, utility usage, if the third party uses the data for secondary commercial purpose, the contract between the public utility and the third party shall provide that the third party will prominently disclose the secondary commercial purpose to the customer, and that the third party will secure the customer's consent to the use of his or her data. I think that's the overall theme basically throughout this regulation, is if the utility releases the customer data and the release of that customer data does not fall within an exception of subsection F, then customer's consent must be obtained. And full disclosure to the customer, so the customer understands if the customer chooses to consent to the release of his or her information. All right, there's also a section that basically informs the utility, you are to take reasonable security measures and practices to protect customer data. The exceptions I've been talking about fall in subsection F, some of which include, of course, customer data can be relinquished if the customer agrees to disclosure of their data. Other exceptions include the utility disclosing customer data upon the valid request from law enforcement, to restore power after a storm, to respond to customer complaints. Some other sections of the regulation include, one of which I think is important, because if this regulation is approved by the General Assembly, utilities will have to, within 180 days after the effective date, I'm under section H, 180 days, they will have to file guidelines with this commission, when the guidelines will include under H2 a minimum of the following issues: customer notice and awareness, customer choice and consent, customer data access, data quality and security procedures and measures, and then public utility accountability and auditing. I apologize, Melissa. I need to go back to India and I didn't tell you. So, Mr. Chairman, those are the highlights that I have. If I may just ask one question, Mr. Chairman. The last document that I told you about that we served on the stakeholders yesterday contains comments that were filed as of August 3rd. And as you go through and the parties talk, if you don't mind, I might ask if I can display that document after they finish, meaning the document contains the proposed regulation as it was published in the state register, plus the comments that were filed on August 3rd. And so I don't think Ms. Liebarker will mind if I use her as example. So let's say the Department of Consumer Affairs completes its comments, Mr. Chairman. I might ask if I can display the document that we served on the stakeholders yesterday and ask if there's an issue with what we served. It's basically a composite document of everything I think that we've received thus far. And I think it'll be helpful as the commission makes its decision.
Can we do that now?
I can show it to you. Yes, sir, Mr. Chairman. Let me show you what I'm talking about.
Ms. Boyd, may I ask a question?
Sure.
In that document, you or whoever prepared it color-coded the comments of different entities who provided those comments. Is that correct?
Yes, ma'am.
So depending on the color, you can tell if it was a comment made by the Department of Consumer Affairs or by Dominion Energy or by one of the Duke Energy companies.
Yes, ma'am. And we did, yes, Madam Vice Chair. It starts here, Mr. Chairman. So the legend we included at the top, for example, right here. So South Carolina Department of Consumer Affairs, the way we interpreted that what we thought their comments as of August 3rd, there would be in red. So we then place those comments within the proposed regulation, if that makes sense. Now, Duke Energy Carolinas and Duke Energy Progress, what you see, I think we accurately captured because they provided a red line and a blue and red line version. And I think I'm correct that Dominion did not have any further written comments. But my point being, Mr. Chairman, I think perhaps this might be a good guide. The document that's being displayed right now, perhaps. You're the judge, you're the chair. I just wanted you to know that this is there. So as people talk, perhaps we can ask them eventually to refer back to this and say whether they think the document is okay or it's not. Does that make sense?
Makes perfect sense.
All right.
Understood. Any objection from displaying this document from the parties? All right, hearing none.
No objection.
No objection, okay.
Okay. And Mr. Chair, Melissa, I'm going back to NDI now, so, okay. Thank you, Mr. Chairman.
All right. Town of Irmo, comments?
Yes, thank you very much, Mr. Chairman. If it's okay with the commission, I'm going to make these comments and bow out of the meeting because I think my comments are relatively simple and non-controversial. As you are aware, Blue Granite provides sewer to a large portion of our town, and many of our citizens believe that the rates they're being charged for sewer are very high, and we have some portions of the town where the citizens have very modest income. As a result, we are having many of the citizens who are served by Blue Granite unable to pay their sewer bill, and they're being cut off. What's happening is when they're cut off, they still continue living in houses. And what they will do is they'll go outside, disconnect the sewer pipe, and just dump raw sewage on the ground. We are in a posture to where the town needs to know when a sewage customer is cut off so that we can be certain to send our code enforcement officers out from time to time to ensure that we're not bypassing the system and just dump raw sewage on the ground. Our request is, and we have an agreement with Blue Granite that they give us the customer information that the service has been stopped and involuntarily cut off. We obviously have our differences with Blue Granite in regard to what they charge us, but the new management seems to at least be trying, and we have a consensual agreement with them. They will let us know when service is disconnected or stopped so that we can check to make sure raw sewage is not being dumped. So whatever we wind up doing with this rule, we hope that we can have a provision written in to where nothing precludes the utilities from providing the local governmental bodies notice of when the service is terminated. We think that it could be read to where the termination of service is confidential information and cannot be shared with the local authorities. All we seek is that the agreements that we presently have in place with Blue Granite, which they are very kindly honoring, be allowed to continue so that when sewage service is stopped, we can make certain that alternate arrangements are not being made by the customer, which would certainly violate the environmental laws. With that, that's the only comment we have. And I thank you so much for allowing us to make this comment. And unless there are any questions for me, I will thank you for the time you've afforded me this morning, and I will hang up.
Any questions for the town of Irmo?
Mr. Chairman.
Yes, Vice Chair.
Thank you, Mr. Chairman. Good morning, Mr. Moore.
Hello, Commissioner Belser. It is nice to talk to you again.
Mr. Moore, I note that under Section F, the section that is titled Exceptions to Sections A through E, under F subpart 3, it states, this section shall not preclude a public utility from disclosing customer data in the course of its operations, A, where necessary to provide safe and reliable service. That seems to cover what you are talking about here, in my opinion.
Well,
and then in B, and in B, it's also as required or permitted under state or federal law or regulation or by an order of the commission or to a governmental town or municipality.
You know, I have read that. We have had discussions with Blue Granite, and they are concerned that it is not clear enough, and if we could just have something added which simply says nothing in this regulation precludes the utility from advising the local municipality of the termination of service. That way, there is no ambiguity in the regulation, and it would resolve our concerns all the way around. I believe, as written, it probably says it's all right, but we would certainly like to have it clear, because Blue Granite is now telling us when the services are turned off, and you know, we just want to make positive that there's no misunderstanding that this regulation does not tell them they can't do that. And just one little section in there which would say nothing precludes the utilities from advising local municipalities when service is disconnected. That ends it. My concerns are totally alleviated. I think it removes any conceivable ambiguity, and it helps us in the town maintain safe compliance with the environmental rules and regulations that apply within our borders of our town. And I thank you for listening to me. But
well, I
hear you.
I appreciate that clarification and that suggestion, Mr. Moore. Thank you very much.
Commissioner, always thank you for your courtesies, and thank you for the good question and just everything. Y'all are wonderful.
That's all I have, Mr. Chairman. Thank you.
Thank you, Vice Chair Belzer. Any other questions for the town of Irmo? Hearing none, moving to ORS.
Thank you.
Yes, sir, Mr. Moore. ORS. Any comments from ORS? Attorney Huber.
Thank you, Mr. Chairman. And I will be brief, and really just have two comments. And one is to the draft that was circulated yesterday, the red line draft. One concern we noticed is in subsection A, in the definitions, there appears to be a different definition for personal identifying information under number 3, and then there's a different definition for that same term later on. And I think this is a result of some of the comments that Duke provided and that the consumer advocate provided. I think somehow those two need to be joined. I don't think that term can be defined just in the manner that Code Section 39-1-90 define it, and also 16-13-510 define it, because there's certain items, information listed previously that would not be covered by those other definitions. For example, those other code sections don't cover email addresses, telephone numbers, and they don't cover customer names and addresses by themselves. That's one comment we wanted to make. second is in subsection C, and I would say this is really non-substantive. In C1, it talks about sharing, disclosing, or otherwise making accessible a customer's data, and then C2 talks about selling a customer's data. In C2, there's some language there where it says or any other personal identifying information. We think that language or any other personal identifying information is not necessary there because customer data, the definition of customer data already includes personal identifying information, and to some extent it suggests a difference between those two clauses that doesn't really exist. And those are really just our only two comments based on what was provided yesterday.
Okay, thank you very much. ORS, South Carolina Department of I'm sorry, Commissioner Vice Chair Belzer.
May I ask a question?
Absolutely, ma'am.
Good morning, Mr. Huber.
Good morning, Vice Chair.
With regard to ORS's concern regarding Section C under C2, the last point you just made about the difference in customer data or other personal identifying information, I do note that those terms are both with the addition of in yesterday's draft, that those are two separate terms defined now in this latest draft. Does that impact your comment in any manner? Because if they are defined separately, should they not both be listed in C2?
Thank you, Vice Chair. The way I read the latest draft, and I think this is one of the issues with there to be one definition of personal identifying information under the definition of customer data in 3, and then there's a separate, different definition of personal identifying information in purple later on. And the way I read the draft suggested is personal identifying information is still included as part of the definition of customer data.
Okay, so if we accept and do a set definition for personal identifying information, and in this draft it's not numbered, so those definitions would have to be of terms would have to be renumbered if we accept that. If there are two separate definitions, one for customer data and a separate definition of personal identifying information, would you agree that they both need to be referenced in C2?
Yes, I would agree, and I would add that they all should both be referenced in paragraph 1, where currently paragraph C1 only says that customer's data, so it would also need to say and
or personal, okay,
or personal identifying information, and I would. That's the only two places I'm aware of that would need to be added, but
okay.
If that change were made.
Thank you, Mr. Huber. Thank you, Mr. Chairman.
Any other questions for ORS? Hearing none, South Carolina Department of Consumer Affairs.
Thank you so much. We appreciate the opportunity to be here today and even virtually to discuss this important regulation that is kind of near and dear to our hearts. The Department of Consumer Affairs has been the state's consumer protection agency since 1975, and we administer and enforce over 120 statutes. Since 2008, we have been responsible for enforcing the Financial Identity Fraud and Identity Theft Protection Act, which relates to what we're talking about here today. Obviously, the comments that we submitted were intended to share information just based on our experience and our administration of that act, and also the breaches that we see and the types of information that unfortunately are breached on a regular basis. And we wanted to share that information for you to do it as you wish in this regulation. we wanted to make you aware of the various definitions of personal identifying information. And we do think, and I'm glad that you brought up the document earlier, we do think that there are some inconsistencies about the definition of PII in the proposed regulation or the draft that was circulated yesterday. And we believe that the Title 16 definition is broader than the Title 39 definition, and but certainly, that would be in the Commission's will whether to use the Title 16 definition, the Title 39 definition, or to possibly, not use either definition, create your own definition, and possibly call it something other than PII just to avoid that confusion. But other than that, we appreciate the document. It accurately reflects the comments that we offered, and we are happy to answer any questions. Ms. Leibarker and I both are available to answer questions if there are any.
Vice Chair Belzer.
Thanks, Mr. Chairman. Good morning, Ms. Rainsford. It's nice to see you. It's been a few years since our paths have crossed.
It has. Good morning, Vice Chair.
Did you hear my discussion with ORS Attorney Huber?
Yes, Vice Chair, I heard the discussion.
Okay. Would the consumer advocate support having a separate enumerated definition of the personal identifying information or other term that may cover what is what I think, the Consumer Advocate's Office had added to the definition of customer data, and then another party who was at Duke added a separate term and definition. If we were to combine or come up with our definition of what we consider to be PII or other similar term and just have it as a separate defined term, do you think that may alleviate some of the ambiguity you might have been referring to?
Yes, I believe so. If you come up with your own definition, and if you were to avoid the use of PII, that term or something close to that, I think that would avoid any confusion.
Okay. Thank you very much. That's all I have, Mr. Chairman.
Thank you. Great to see you.
Any other questions for the South Carolina Department of Consumer Affairs? Hearing none, moving to Piedmont Natural Gas.
Good morning. As I said earlier, Piedmont has no comments with the proposed regulation, and we're simply monitoring the proceeding today. Thank you.
Thank you, ma'am. Moving to the Duke companies.
Good morning, Mr. Chairman. Thank you. The companies appreciate the opportunity to present their comments today. We work hard to protect customers' data from unauthorized or inappropriate disclosure, and we are supportive of the Commission's proposed regulation. We appreciate the Commission's willingness to incorporate into the proposed regulation many of the concepts and definitions from the Code of Conduct that was approved by the Commission and applies to DEC and DEP. As a result of the Code of Conduct and the company's privacy policies, the companies have established a robust framework to protect customer data from unauthorized or inappropriate disclosure to third parties. And we also report to the Commission when those disclosures occur under the reporting provision of the Code of Conduct. We believe that incorporating this Code of Conduct framework into the proposed regulation will help minimize cost to customers and continue to help facilitate the company's compliance with the code and this proposed regulation if implemented as a final rule. To that end, we offered a few limited amendments to the proposed regulation that were largely non-substantive, and they were outlined in our comments filed August 3rd. But we just like to briefly comment on some of the the Department of Consumer Affairs recommendations in their comments filed on August 3rd. They recommend imposing a due diligence standard when sharing customer data with third parties, and as written, it looks like the restrictions and parameters would apply to all third parties. We believe that in many situations these requirements would be unnecessarily burdensome, particularly in cases where a customer consents or the information shared with a third party is very limited with customer consent or for a targeted purpose. We think that the recommendations also assume the existence of a contract with all third parties with whom the companies share customer data, but that's actually not the case. The companies often provide customer information with the customer's consent to third parties with whom we don't have a contractual relationship. Some examples include where an assistance agency would like to pay a customer's bill. We don't always have an agreement with the assistance agency, but with the customer's consent, we would share certain pieces, defined elements of customer data to allow the agency to pay the customer's bill. Another example is where a customer requests that their specific usage data is to be sent to a third party for energy analysis, where we don't have a contract with a third party, but we or the third party, and before we disclose the data, we have the customer's consent to do so. We just don't have a contract with a third party. So those are really our just kind of big picture takeaways and recommendations on the consumer advocate's comments. We did some areas of agreement. The consumer advocate recommends defining customer data so that it makes clear that former customers' data should be treated in the same way as current customers' data, and we already do that. DEC and DEP already treat former customer data in the same manner as current customer data, and we don't disclose it without customer consent. We would also note that just for the Commission's consideration, there is an ongoing rulemaking on this issue in North Carolina, and the companies, both DEC and DEP, operate in 2 states, and having rules that apply in one state and not another could create some operational complexities that might be difficult to accommodate, and so we've taken those potential complexities into consideration when filing our comments in this docket, and we think that the proposed regulation with the limited amendments that we offered in our comments on August 3rd would address those potential operational issues. That's all I have, Mr. Chairman.
Thank you, Attorney Brown. Any questions for the Duke companies?
Mr. Chairman, this is Commissioner Irvin. I have a question.
Yes, sir, Commissioner Irvin. Please proceed.
Thank you. Ms. Brown, thank you for your comments this morning. I anticipated that since Duke Energy operates in both Carolinas, that perhaps it would be best if we tried to mirror our regulations with the North Carolina Commission regulations, so that, and of course, Dominion and Piedmont also would be bound by the North Carolina regulations. So all the more reason why perhaps we should try to parallel the launch as best we can. Do you see any reason why that would not work in the South Carolina regulation?
Thank you for your question, Commissioner. No, I think that the proposed regulation as the Commission has issued it, and this is not taking into account all of the comments and changes made by the parties in the document that was circulated yesterday, but we believe that it takes into account those issues with the cross-jurisdictional issues and with DEC and DEP both being bound by the Code of Conduct. So we've worked towards that and considered that very carefully in filing our comments.
Right. So am I hearing you saying that as the regulation currently stands, the proposed regulation, Duke Energy would be supportive of the language as proposed?
Commissioner, we would be. We offered some just limited amendments to the proposed regulation that were really non-substantive, but largely as written, we would support it. We think that those definitions are consistent with the Code of Conduct and also consistent with the proposed regulation submitted by the North Carolina Public Staff that was supported in large part by DEC and DEP.
Very good. And do you have any feel when the North Carolina Commission will be adopting the regulation? Do you know what the status of that proceeding is?
I believe that the latest was that we filed, DEC and DEP filed comments, but I don't believe that the Commission has taken any action. I'm not really sure when they're expected to do that. But I think that they're a little farther along than we are in South Carolina.
So we would hopefully have a chance to see their final reg if we needed to before we adopted ours. Would that be fair to say?
I think that would be fair to say. I'm not sure of the timeline, Commissioner.
Sure.
But obviously that would be ideal. And I would just add to my response earlier that we would like to file comments on the latest updates to the proposed regulation. Those updates were circulated yesterday afternoon. Before we could say we would sign off on anything, if the proposed regulation is updated to include the comments of all the parties, we would like to have an opportunity to file comments on that.
Absolutely. Yeah, absolutely. I'm not trying to bind you to any position. I'm just trying to get a better understanding of where you're coming from.
Of course.
Thank you. Mr. Chairman, those are all the questions I have.
Thank you, Commissioner Irvin. Any other questions for the Duke companies? Hearing none, we will move to Dominion Energy, South Carolina.
Thank you, Mr. Chairman. Belton Ziegler, on behalf of Dominion Energy, South Carolina. Dominion wants to thank the Commission for giving them the opportunity to comment on the regulation, and also wants to commend the parties for the very cooperative and positive approach that has characterized the work to date. Dominion filed comments in March on the proposed regulation, and the focus of those comments were concerning operational issues that would apply in the field, in storm context, in dealing with law enforcement, in dealing with governments, and trying to be sure that nothing in this regulation would cause on-the-ground problems in delivering safe, effective, efficient, and reliable utility service, which is Dominion Energy's goal here. Those comments, and we thank the Commission staff for this, and other parties, were accepted as appropriate, and that is a big chunk of what's now in Subpart F, which is the set of exceptions. We have to join with Duke in raising a concern about the most recent set of comments that have been put in by the Department of Consumer Affairs. And I should also mention that in a letter dated August 3rd, Dominion Energy, South Carolina, indicated that it did indeed support the regulation as it was forwarded to the General Assembly and has been noticed as a proposed regulation, and that continues to be the case. What are the concerns with what the Consumer Affairs Department has put forward? Well, as we read the section that is now J, the new section, it would require, before any use of the exceptions in Subpart F, the company would have to conduct due diligence to verify that the third party understands and is capable of complying with privacy laws, that it would have to establish ongoing monitoring to determine compliance. It would have to review the third party's policies, procedures, internal controls, and training materials, and determine that the third party conducts appropriate training and oversight of employees. It would have to have a contract with enforceable consequences for violating any compliance-related responsibilities. And that might make sense in some financial or commercial context. It doesn't really make sense, I'm afraid, in the utility context. Imagine, if you would, a major storm coming through any of the utility service areas in South Carolina. The mutual assistance provisions that exist would then be implemented, and construction crews, vegetation management crews, line crews, both private and utility, both third party and utility, would be called in from all points of the compass to help in the restoration efforts. How would you conduct due diligence to verify the compliance with privacy laws, as would be required, because to do this restoration you have to share information about which customer is whom, which customer has service at what voltage, which customer, what phone number do you use to contact the customer. You have similar issues when you're dealing with vegetation management on a standard basis, where you're going into when you have a contractor going into a neighborhood to do tree trimming. The contractors want to be sure that they are in contact with the customers, that they have to know who those customers are. The similar issue comes up with law enforcement. The utilities deal with law enforcement agencies throughout their service territory. They also deal with municipalities, both in the context that Mr. Moore discussed in the town of Irmo, but also one of the things that's being done to protect customers' interest is that Dominion Energy South Carolina shares its customer list and addresses with each municipality where it has a franchise, so the municipality can be sure that Dominion Energy is not putting franchise fee riders onto bills where the customers are not really within the limits of the city. Under this proposal, DESC would have to go through due diligence, auditing, monitoring, reviewing of policies, procedures, internal controls, and training materials for every municipality within its service territory, in effect, almost every law enforcement agency within its service territory, and any entity that was going to be coming to do storm restoration work and would need customer information to do it. I don't think that's workable. I don't think that is a thing that anyone, the Consumer Affairs Group, I hope would not think that that would be a reasonable way to conduct utility operations. There is a requirement for a contract and for appropriate protections where you're sharing information outside of these exceptions. That's in F3P. We think that's adequate to deal with those issues. I would also raise the question of the costs that would be involved in applying this sort of oversight. As the Commission is aware, whatever the company has to do to run its system ultimately has to be paid for, as long as it's prudent and necessary, by customers. So if we were to impose these sorts of very precise and we would say administratively complex requirements on the utility system, those costs eventually will go to the customer, and they will not be inconsequential. You're talking about, in all likelihood, the major utilities in this state having to hire multiple people to go through this process of due diligence review, monitoring, reviewing training materials, internal controls, that sort of thing. So we would suggest that the benefit to customers from having that sort of requirement would not justify the costs that customers would have to pay. We're not aware of any burning issue concerning these sort of operational uses of information that are causing privacy concerns. If those do arise, obviously we'll deal with them. Customers, as the Commission knows, as Duke has pointed out, we all operate under codes of conduct. We all have very strict customer privacy laws that apply, both from those codes of conduct and from general privacy laws in South Carolina, and as promulgated on the federal level. So we don't really see the benefit of adding this level of administrative work to the process. The other point we would make is that the provision in the new section F on frequency of notice to customers would also, we think, not pass the cost-benefit test. The company's privacy policies and data security policies are publicly available on its website. They're very easy to locate there. That is, again, a regulatory requirement that the company follows. This provision would require that the company notify its customers in writing, both initially and annually, of its policies. As we see it, that would require a mailing to customers of these policies. Mailings are expensive, and we just don't see that requiring a written document to the customer's addresses for that purpose would be a reasonable use of utility funds. Again, the customers end up paying for that, and we just don't think it would be appropriate. So with those comments, I think I could say that Dominion Energy, South Carolina generally supports the regulations, certainly supports it as it's been presented to the General Assembly, but would ask that the Commission look very carefully at those two new sections that have been proposed by the Consumer Advocate, and we would ask that those not be included in the final regulation. Thank you, Mr. Chairman.
Thank you, Attorney Ziegler. Any questions for Dominion Energy South Carolina?
Mr. Chairman, this is Commissioner Irvin. I have a question for Mr. Ziegler, please.
Yes, Commissioner Irvin, the floor is yours.
Thank you, sir. Mr. Ziegler, good morning. How are you?
Good morning. How are you?
Fine, sir. I understand your last comment about the cost of a mailing. Could that not be accomplished in a bill insert rather than a separate mailing?
It could be done as a bill insert. It would still be there's still cost involved in printing close to 2 million copies, because that's about somewhere in that neighborhood is where you are with the customers, both gas and electric. And adding it, if you're putting the entire policy in there, it might really require a separate envelope. I'm not certain what the limits are with the mailing agreements that they have with the post office for those documents. A number of customers now take electronic service of their bills, and this specifically says in writing, so you would have to do a special mailing to those customers if you were to adopt that language.
Do you have any idea what the cost would be for a mail insert that maybe just a summary of the provisions and the referring back to your website for further information? You could post the entire document on your website.
I could certainly have the company provide you with that information. I don't have it at my fingertips.
That might be helpful just to weigh the cost benefit
sure.
In terms of notification. And if in addition, if you could provide us with a number that you can contact electronically, I guess that would also could be a factor if they're, do you have any idea how many customers can be notified by email?
I'm afraid I don't. That's not a number that's come across my...
Right. Okay. But I appreciate your concerns, and certainly I think you've made valid points in terms of having to deal with customer outages. There are times where some of this information has to be provided to third-party contractors and perhaps to law enforcement to provide service restoration. So I think those are very valid concerns, and we'll certainly take a close look at that. I appreciate your attendance this morning.
Thank you, Commissioner.
The final question I have for you is, I think what caught my attention, and the reason I asked for the docket to be open, is the reports that we saw in the news media that Dominion had allowed a third-party vendor to send out letters to its ratepayers, apparently all its ratepayers, advertising a product, but the Dominion logo was on the return address, so it was it created customer confusion about whether this product was being manufactured or offered for sale by Dominion or someone else. I think that you understand why we would be concerned about that.
Yes, sir. I think the company is very well aware of those concerns.
And so you wouldn't have any objection to having a language in the regulation that addresses that concern, would you? The company would not.
And the company, I think, has stated it's in accord with the regulation as it was provided after the council of March 12th. And so, yes, that's never been an issue as far as the company is concerned. Our only comments have dealt with these operational concerns.
Yes, sir. Thank you very much. That's all the questions I have, Mr. Chairman.
Any more questions for Dominion Energy, South Carolina? Attorney Boyd.
Mr. Chairman, I don't know that this question is related to Attorney Ziegler's issue with Section J, but I wanted to ask him and also ask Executive Director Liebarger if they have an issue with considering the due diligence issue being addressed in those guidelines, because I'm just thinking that the guidelines for each industry could be a little different. If this regulation is about the General Assembly, then you'll be seeing within 180 days, the commission will guidelines, I think, and I'm looking at Section H, public utility guidelines that have to be filed with the commission after this regulation becomes effective. So if that's the case, I don't know that each utility's guidelines will mirror the next. There will be, I don't know what the level of similarity. So what I was going to ask of those two, Attorney Ziegler and Executive Director Liebarger, is if they have, and would they consider any due diligence standards that they have or whatever due diligence they use, that be included in the guidelines? Because to me, that'll be utility specific, perhaps. And if it's covered by their code of conduct, perhaps in that docket or those dockets, they can inform the commission of that, whatever their due diligence is. I was just trying to, before you close the proceeding, Mr. Chairman, just trying to look at that issue, if it's really important to the consumer advocate, and if the utilities are already, that issue is already being addressed. In the future, it's going to be addressed in individual dockets anyway. Could perhaps there be a section added for due diligence where each utility addresses what their due diligence is? Just something, if you don't mind asking those two persons.
I don't mind you asking at all.
Oh, Ms. Rainsford, I apologize. Attorney Rainsford, please forgive me. I haven't met you yet, so. Attorney Ziegler, did you understand what I was suggesting there?
I did, and I would have to, obviously, it would make sense, I think, in the abstract. I haven't consulted with my client that that could be an element of a utility-specific guideline, and that would give us a venue to be very precise about how to apply those rules, the due diligence rules, if there are any, where they need to be, and not in places that would be unreasonably burdensome or disruptive.
Thank you. Oh, yeah, and I see Attorney Rainsford. Hi, Ms. Liebarker, I saw your face. But Attorney Rainsford, would you like to respond?
I believe Ms. Liebarker.
Oh, she's going to, okay.
Better than I on that one.
Thank you. Oh, we can't hear you just yet. Are you muted, Director Liebarker?
I was.
Okay.
Yep. Very good. Thank you. Good morning, everyone. I think that that's a great suggestion. This is just a framework that we've seen utilized in other areas, other industries. I think our main concern would just if there is some kind of formula or some kind of framework put in place to give guidance to utilities on coming up with what that due diligence fits best for in their particular areas. I mean, with the in writing, I mean, we have loan applications and mortgages and all sorts of stuff that have to be in writing, but electronic is certainly available as the method in getting that to consumers. So having, something like that delineated within there as well. But just to make sure that we have some kind of due diligence going on, because it's often not the original party that we see security breaches through. It's the third party that's contracted with the particular company and received information from it that the breaches occurred. And so that's why we think it was an important element to include in our comments.
Thank you. And thank you, Director Liebarker. And Mr. Chairman, Attorney Jerisha Dukes informed me, thank you, Attorney Dukes, that Duke Energy, Ms. Brown, did you all comment? Yes, you provided comments about the due diligence language, and I apologize that I did not reference you. Did you understand the suggestion that I was making as it relates to due diligence, and then the commission considering each utility's due diligence practices in their dockets when these guidelines are filed with the commission?
Yes, Ms. Boyd, we think that would be a reasonable solution to consider putting that in the guidelines that would be utility specific.
Mr. Chairman, thank you for your indulgence. Thank you.
No problem, Attorney Boyd. I have a general question or maybe comment for the parties and for the commission attorneys. Obviously, this matter was initiated while I was away, but in my review of the documents, and I could have missed it, Lord knows I could have missed it, I didn't see much of a penalty provision here, a strong penalty provision. And for me, in many situations, sorry is just not enough. And so to ensure that those who are responsible for protecting this information actually feel the need to do so, and maybe some encouragement to do so, should there not be some strong penalty provision to punish violators of this regulation?
Let me, Mr. Chairman, I wanted to look real quickly. I know there's a penalty section in our regulations. Okay, so I think that's something the commission can consider. Mr. Chairman, I'm going right now. I'm looking at Regulation 103-87, and I'm trying to determine. Okay, so 857A just says any fine or penalty assessed by a person is allowed by statute, and this is not a statute just yet. Yeah. Because basically, I knew that any fines or penalties that you all assess would probably go to the general fund, be remitted there. But I don't think we have a statute. Let me look right quick. Yes, sir. I'm sorry, Mr. Chairman, go ahead.
Someone speaking. Who is that speaking? Is that Commissioner Urban?
This is Commissioner Urban. I'm sorry.
Yes, sir. Please proceed.
Perhaps, Ms. Brown, you could tell us, does the North Carolina draft have penalty provisions? Do you recall? Do you hear me?
I do. Thank you for the question. And off the top of my head, I'm not sure about that, but
Right.
we can get that information and provide it to you after the hearing.
That would be great. If you could forward it to Ms. Boyd, it might be, again, helpful to have similar language since the companies are doing business in both Carolinas. It might save us from having to reinvent the wheel as well. So if you could provide that information at your convenience, that would be great. Thank you.
Thanks, Commissioner. Yeah, we would be happy to do that.
And Ms. Boyd, my suggestion would be, since we don't have a statute, just to include a penalty section in the regulation. It could be drafted. I'm betting that North Carolina has a similar provision, so that might give us some guidance in terms of how best to approach it. Thank you, Mr. Chairman.
Okay. Yes, sir, Commissioner Urban. Mr. Chairman, would you like for us we can review the comments from Duke? And also, I just did a quick search under Title 58, Chapter 3. I see one reference to penalty. I was just trying to search, because Chapter 3 would basically cover, it's everybody, all of the different utilities. And
Well, let me ask you this, Attorney Boyd. Does the commission have the authority to issue penalties?
I think when it's allowed by statute, at this point.
Okay. We don't know whether it's allowed by statute, or from what you're reading, I don't think you see anything that allows it. I don't want to put words in your mouth.
Yes, sir, not yet. My initial search, the section, the chapter where I would think would cover the commission as it relates to all utilities would be Chapter 3. Title 8, Chapter 3. And I did one search, and I found it's located in 58-3-220, but it doesn't cover all the utilities. So I'll look into it, Mr. Chairman, if that's okay, and Commissioner Urban.
Commissioner Belzer?
Yes, ma'am. Thank you.
Yes, sir.
Vice Chair Belzer?
My recollection is that there was a penalty provision maybe under telecom. And telecom and electric utilities track very close, but those penalties had to be enforced through circuit court. So the commission is very limited on any penalties any monetary penalties it can levy. Now, how violations may come up in the rate-making process might be another issue, or you never know, but we're very limited on being able to issue any kind of monetary penalties.
Thank you, Vice Chair Belzer. I hate to be a cynic, and I don't want to prolong this public hearing, but just playing the role of devil's advocate, what difference does it make if I'm a regulated entity and I violate this regulation? So what? What are you going to do? What are we going to do? What's going to happen to me? Nothing?
This to me is worst case. I mean, I'm being creative right now, Mr. Chairman, a rule.
Oh,
should you be able to operate? You violated, I understand what you're saying.
A rule to show cause.
Yes, sir. That's the best I can come up with right now. When you don't cooperate and you violate the rules, okay, a rule to show cause is filed as to why you should be allowed to continue to operate. I know, Commissioner, did you hear Commissioner Belzer, Mr. Chairman?
Her microphone not on.
So anyway, that's the best I have right now.
So,
Mr. Chairman, if I may, this is Sam Wellborn.
Yes, Attorney Wellborn.
I don't know if this will be helpful or contribute to the conversation, but I'm thinking of a complaint proceeding or just a standard run-of-the-mill complaint proceeding not related to customer information. And I think the ultimate goal is to bring the utility into compliance, to determine, I guess, first, whether the utility is in or out of compliance, and then to bring the utility into compliance through that complaint proceeding. I think the regulation as drafted does contemplate regulatory enforcement of this regulation. And to me, that's what the process would look like. There would be a hearing to evaluate whether the company or utility was in compliance or not. and then to determine, steps forward in terms of bringing the utility into compliance. And I don't know if that has enough teeth for you, but as compared to, for example, a generic complaint proceeding, I would imagine that would, travel along the same path.
Thank you for sharing that, Attorney Wilburn. I definitely understand that process. I just tend to think that penalties, stronger the penalty, quite possibly, the easier it is to get compliance. Stronger penalty, higher compliance. I don't know. Maybe that's thinking like a prosecutor. It may not necessarily be the case, but as I read through this, it just made me wonder, okay, let's just say a regulated entity violated this regulation in a big way, released a lot of protected customer data that should be protected at least. Someone complains, we have a hearing, we rule and find that they violated the regulation, and then we encourage the company, or we rule that the company needs to come back into compliance, and that's it. It just seems a little wanting, but maybe it's something I could be missing. Any other questions or comments? All right, hearing none, this proceeding is adjourned. Oh, I'm sorry. Oh, the deadline.
I'm sorry. Mr. Chairman, I apologize. It's an unrelated subject. If the Commissioner indulges me just a moment, this is Chris Huber for RS. In thinking further about Vice Chair Bell's suggestion to me, one thing I wanted to just point out briefly is if the Commission does separate personal identifying information as a separate term, completely separate from customer data, there are other places in the reg where the language may need to be changed, and it may need to add "and personal identifying information," because currently it just says customer data. I think it's just a situation where if you change one definition, it can have spillover effects elsewhere. And I would just request that, similar to Duke, that if there is a updated draft issued by the Commission, that ORS have an opportunity to file comments. And finally, I neglected to do this earlier. I would like to thank the Commission for considering the reg that we proposed and for proceeding forward with it.
Thank you, Mr. Huber. I appreciate your clarification and additional comments on that. Thank you.
All right, so my Attorney Dukes is advising me that we're going to keep this docket open. I'm sorry, the record open until high noon on Friday. What's the date on Friday? The 18th. So the record will be open until noon for the 18th. I'm sorry? For any additional comments.
Mr. Chairman.
Yes, Commissioner Whitfield.
Thank you, Mr. Chairman. Just one brief question, if I might, for Commissioner Belser, if I could. She had an exchange with Attorney Moore about Section F. I think it was B she cited, and he brought up concern about, of course, a municipality being able to access the information, and he used a very specific example. And I just wanted to ask Commissioner Belser if she thought the language in that Section F covers his concern. And I'm not talking about, Commissioner Belser, only a municipality. I think of, in here it does say town municipality, but I also think of South Carolina EMD or FEMA or any of the emergency agencies that might have a legitimate emergency urgent need in a manner where they're trying to help people and help the customer. I just wanted to, Commissioner Belser, if you could maybe address where you were citing in Section F.
Commissioner Whitfield, I referenced those as a question to Attorney Moore to see if he thought that those covered his concern, and his response was that he did not, and he thought that it needed some additional specificity elsewhere. Now, further discussion among the regulation, we can do that as we debate this issue and as it comes up, but I don't know where staff may go from this and what additional comments are going to come in, and I'll leave it at that for the moment. Thank you.
Well, thank you. And as the chairman stated, he would, as he said, Ms. Dukes just said, we'd leave it open. So I do see where there could be some concerns there. Thank you, Mr. Chairman.
Thank you, Commissioner Whitfield. Are there any other comments before we adjourn this hearing? All right, hearing none, again, the record in this matter will be left open for additional comments until noon this Friday, noon, September 18th. The record will be left open for additional comments. Thank you for joining us today. Hope you have a great day, rest of your day.